Welcome once again to Lehto's Law. Here's Steve Lehto.
Every now and then I mention that someone sent me such a simple, distilled question. It's one sentence, and it's instantly understandable what they're getting at, and it's a good question. And I think I've mentioned that twice now, where people have sent me a simple one-sentence question, and I'm like, boom, that's a good question. And every time I mention it, I get a bunch of people who are apparently trying to do that. They send me one quick question. It's an art form. It's like writing a haiku, right? I mean, everyone knows the rules, and you can write them all day long, but to write a good one? So I got another good one-sentence question, although he asks a follow-up to make sure I understand the question. But it's actually a question I get asked a lot, and I see it a lot in the comments below my videos. And so this was sent to me by Ron. And Ron says, hey, Steve, my name is Ron. I have a question I'd like to ask. If a person is called to testify, when they're put on the stand and asked, do you swear to tell the truth? What would happen if you said no? Question is, if you are called to testify in court and they put you on the stand, I've said before, once you're sworn in, you got to tell the truth. What if you say no? No. Raise your right hand. No. What happens then? And a lot of people ask that because they think, hey, you know where the problem started when you raised your right hand and swore to tell the truth. Problem actually probably started back when something happened that you were a witness to. But we won't go there. The question is, can they force you to raise your right hand, take the oath, and then testify? And there's a bunch of things that go into this, and that's why it's such a great question. But I get asked this all the time because, you know, we've all seen it a million times. You've been sworn to tell the truth. You must tell the truth. You understand the penalties for perjury. Now, tell the jury, what did you see? Oh my gosh. So it's a great question. And it occurs to a lot of people. And what it gets down to is why you are there. Okay, so you're subpoenaed to appear in court. But I'm going to back up and let you know that a lot of people actually testify at depositions before they go to court. And likewise, at a deposition, you're sworn to tell the truth, the whole truth, nothing but the truth. And you're also there because of a subpoena. And so the traditional situation finds you testifying someplace because you've been served with a subpoena. And the subpoena says, notice too, and it's got your name there, your address. And it says, you are hereby ordered to attend, and it has a name and a place and an address and a phone number, contact information of some place you've got to go and testify. And it'll often say at 9 a.m. on Monday, you're ordered to testify, and you will be required to attend from that moment on until released by the court. And it'll often say, you know, you may be called back, and there's a bunch of other stuff. But let's just go off the simple model. That is, you're going to testify Monday at 9 a.m. You get the subpoena that says you must appear Monday, 9 a.m. Now, you might say, Steve, can't I just ignore the subpoena? Well, you can, but it'll get you in trouble. Okay? But you know, you can lead a horse to water kind of thing, right? So obviously they serve you a subpoena, you could just choose to ignore it. Now, if you choose to ignore the subpoena, which I'd never advise you to do, you can be held in contempt of court. And you might get dragged in front of the court with a show cause hearing to explain why you didn't respond to the subpoena. And the subpoena is a court order. If you look at the subpoena, it'll actually say with a case caption at the top and a case name and a court, you are ordered to attend. And then at the bottom is a signature and a state seal and all kinds of other stuff. It's a court order. So it's like any other court order. You need to follow the orders of the court. And if you don't, you can be held in contempt. So what would happen if you didn't respond to the subpoena? Somebody's going to go, hey, where's so-and-so? They didn't show up. Did you serve them? Yes, they've been served. Okay, we're going to issue a show cause and drag them in here. And they'll get dragged in. And guess what? When the judge starts asking you questions, you need to start answering as to why you ignored a subpoena. And the funny thing is that he did ask as a follow-up something to the effect of, have you seen this ever happen? And in 31 years of practicing law in the state of Michigan, I personally have never seen someone who ignored a subpoena, where I served a subpoena on them or someone served a subpoena on them and the person didn't show up. Now, I did have a case where I wanted to serve a subpoena on somebody, and the guy said, if you served it on me, I won't respond. And I wasn't quite sure what to make of that, but the case settled. And so I don't know if the guy would have shown up or not. He told me he wouldn't, but the case settled. So I don't know. But the point is that you get served with a court order, a subpoena, that says you must show up. So you show up. You're in court. Court gets through all its preliminary stuff. Going to start the case, opening statements, call your first witness. Plaintiff calls and they name you. You might be in the gallery. You might be out in the hallway if they said that people have got to be outside, different things. They bring you in. You walk up the front and the judge might ask you, are you so-and-so? You say, yes, I am. Have a seat. Get in the witness box. Raise your right hand. Bailiff will walk up with a Bible. Put your hand there. Put your hand there. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? No. Never seen that. Never seen that. But obviously a person can say no. I mean, physically they can say no. Here's what's going to happen. The judge is going to look at the person and go, no. You've been subpoenaed to be here. You have to testify. You're in the box. Say yes. Now, if you say, I can't, I refuse, well, the judge can hold you in contempt of court. Because the subpoena is not just a notice to attend and be physically there. It's to come in and testify. And the court can order you to testify. Now, I know what some of you are thinking. You're saying, Steve, what about the fifth? Can I take the fifth? You can take the fifth in very, very limited circumstances. Because remember, I said you're a witness. I didn't say you're the defendant. I didn't say there's even an accusation of a crime. This could be a lawsuit. Somebody's suing somebody else. Okay, let's suppose this is a slip and fall that took place in Meyer Thrifty Acres grocery store. And you were walking down the aisle and someone's walking towards you and you saw him right out of the comics do a big old belly flop right on the floor. You saw it. You've now been called to testify about what you saw. Swear to tell the truth, whole truth, no. No? The correct answer is yes. You need to say yes, my friend. Put your hand back in the Bible, raise your right hand, and say yes. Now, some people say, Steve, you're forcing someone to take an oath? How useful is that? Well, I got news for you. How useful is the oath in the first place? There are people all the time who do this and lie. But the point is that you're required to do that, so you do that, okay? So the judge is going to say, I'm sorry, but no is not the correct answer. The only correct answer is yes. So if you say yes, you testify. If you refuse to do that, you'll be held in contempt. And it's that simple. The court can order you to testify. And if you refuse to testify, you are then disobeying a court order. And the court can hold you in contempt. It's going to vary from state to state. I'm not going to get too heavily into this because this is so wildly divergent amongst the states. But the question is, how long can the judge throw you in jail for contempt? And in some cases, they can throw you in jail for a short period of time just based on you saying no and them saying you're in contempt. Go to jail. And by the way, they'll tell you, you know how you can get out of jail? By agreeing to testify. And I have heard of that happening before. I've heard of witnesses who were jailed. I've just never seen it myself, but I've heard of it. I've heard of it in the news. I've read stories about it. And witnesses who refuse to testify can be jailed until they change their mind and agree to testify. But if the detention drags on too long, obviously, number one, the trial could end. They don't need your testimony anymore. But number two, there is usually a limit in a state, whether it's 30 days or 90 days, but some length of time for which, if you're jailed for contempt, that the judge needs to have an actual formal hearing, almost like a trial, to determine the contempt. And in some states, they actually say that it's got to be conducted by a different judge than the one who's actually a witness to the contempt itself. But again, these are all nuances that are irrelevant for our purposes. The simple point is that the subpoena that compels you to appear in court also compels you to testify. And if you are put in the box, told to take the oath, you take the oath, you testify. If you refuse to do that, you can be held in contempt. And if you want to try pleading the fifth, you better hope it works and applies to the case you're in, because if it's a criminal case and you are being called as a witness, and there's a legitimate chance that what you're going to testify to could implicate you. And I'm not going to get into the standards for that because that also varies somewhat from state to state. You might be able to take the fifth. But like I said, I believe the question simply was in a general case like a lawsuit. Okay? You saw the slip and fall. You saw the car accident. You saw whatever it is that led to a lawsuit being filed. You got hit with a subpoena because somebody knew you were there and they said, come into court and testify, and you don't feel like taking a day off or something, right? You're going to get paid whatever the witness fee is, and it might be like $15. You don't feel like doing it, so you don't come in. Number one, they can hold you in contempt for that, issue a bench warrant, and have you arrested. Have you dragged into court and explain why you didn't show up, and almost nothing you say will work, especially if it's just because you didn't feel like showing up. But once you're in the courtroom and they put you in the box and say, take the oath, take the oath. Now, I know some people say, Steve, it's against my religion to take an oath. They've got ways around that too. And so some religions specifically say you cannot swear to tell the truth. But they do say that you can affirm that you'll tell the truth. And so they have different oaths you can take, but they're going to make you take an oath of some sort. And you're going to have to take it, otherwise, contempt of court. So back to Ron with his question. He says, hey, Steve, my name is Ron. I've got a question. If a person is made to testify when they don't want to, when they're put in the stand and asked to swear to tell the truth, what happens if they say no? Can they get into trouble for that? And have you seen it happen? Yes, you can get in trouble. I've never personally seen it happen, but I've heard of it happening. And I've heard of it happening because it hit the news when a witness was thrown in jail for refusing to testify. So there you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Hasta la vista, baby.